Good evening, everyone. A very warm welcome to Macquarie University's City Campus. I'd like to commence tonight by acknowledging that we're meeting in the City Campus on the lands of the Gadigal people of the Eora Nation, the traditional custodians of the land. I pay my respects to their elders, past and present, and to any Aboriginal and Torres Strait Islanders who are with us tonight, meeting with us online. Of course, it's especially important and significant that we begin by acknowledging that these lands were not ceded. Tonight's discussion centres on Australia's human rights record under international scrutiny, and any honest examination of that must begin with the human rights abuses of Indigenous people of Australia and our responsibility to First Nations people. So my name's Lise Barry. I'm the Dean of Macquarie Law School. It's my great pleasure to welcome you this evening. Looking around the room, I can see we've got a fantastic mix of practitioners, academics, students and community members, and it's fantastic to have you all here, and welcome also if you're listening online. Tonight, we turn our attention to the fourth cycle of Australia's Universal Periodic Review, a process that asks every UN member state to account for its human rights performance before its peers. It's a moment of reflection, of accountability, and of opportunity. We're fortunate to have an exceptional panel, and I'll hand over shortly to Amy, who will introduce them, but they're going to bring perspectives from government, our national human rights institutions, and civil society, followed by concluding remarks from Nicholas Cowdery, Chair of the Law Council of Australia's National Human Rights Committee. Before I hand over to Amy, though, I would like to acknowledge our partners and sponsors of the event, the International Law Section of the Law Council of Australia, which provides such an important focal point for lawyers engaged in international law and international human rights law, which has been instrumental in convening this discussion. Our colleagues at Western Sydney University Law School, whose collaboration with the event we deeply value, and I thank the Director of Research, Professor Chris Michelson, himself an expert in international law, for joining us this evening. And finally, Macquarie Law School, which is proud to host this event at our City campus. I'd also like to offer a particular thanks to Associate Professor Amy Barrow of Macquarie Law School and co-chair of the Human Rights Forum of the ILS for her leadership in bringing this panel together. And with that, I'll hand over to Amy to introduce the panellists.
Thank you. I'm really delighted to introduce our panellists this evening and thank them for their time in bringing what they will to this discussion. Each brings extensive expertise and insight into the UPR process through their respective roles. Combined, their accomplishments are so significant that I don't have time to go through all of their biographies, but I'll highlight a few key points in my introductions. So our first speaker this evening will be Rebecca Mills, Assistant Secretary Acting of the Human Rights Branch with the Attorney General's Department. Rebecca is a senior public servant who has worked across a range of roles in the Commonwealth Government since 2010, including in the Attorney General's Department, the Department of the Prime Minister and Cabinet, and the Department of Home Affairs. Currently, Rebecca leads the Human Rights Branch of the Attorney General's Department, where she is responsible for human rights law and policy, including federal anti-discrimination law. And Rebecca also played an integral role in the development of Australia's Modern Slavery Act of 2018. So I wanted to highlight that in particular. Our second speaker, Darren Dick, is Senior Policy Executive on Human Rights and Strategy at the Australian Human Rights Commission. Darren has worked with the Australian Human Rights Commission since 1998, managing the Commission's human rights policy agenda, and he was previously a senior advisor on Indigenous and race discrimination issues. Darren has fulfilled an advisory role for the Commission at a vast range of United Nations and regional forums, including across 3 cycles of the Universal Periodic Review, and Darren was awarded the Public Service Medal in 2022 for outstanding contribution to national policy on human rights. Our third speaker will be Arif Hussain. Arif is a senior lawyer with the Human Rights Law Centre and representative of the Australian UPR NGO Coalition. Arif has worked to strengthen the Australian human rights framework. He has extensive experience working with refugees and with people seeking asylum in Australia, as well as with people subjected to the Australian government's offshore processing regime. This included working on Manus Island to assist people detained by the Australian government. And Arif previously worked at the Refugee Advice and Casework Service. Following our panel discussion, we will then have Nicholas Cowdery, Chair of the National Human Rights Committee of the Law Council of Australia, provide concluding observations and also speak to the Law Council's UPR submission. So Nicholas Cowdery, Order of Australia Officer, King's Counsel and Fellow of the Australian Academy of Law, has been involved in criminal justice for 56 years as a prosecutor, defender, judge, teacher, commentator and campaigner, and for almost as long in human rights. Nicholas has practiced in Sydney, Papua New Guinea, and most Australian jurisdictions. So Nick is director of the Justice Reform Initiative, working to reduce reliance upon imprisonment as the answer to every criminal problem. So I'm sure that you will all agree that we are in highly esteemed company this evening, and I'm really looking forward to the discussion that we will have. So each of our panel members will speak for approximately 10 minutes, and I'll start with Rebecca to ask about the UPR. As this is a peer review process of each UN member state's human rights record, could you provide insight into how the Australian government engages with the UPR, including its response to recommendations made by other member states? Thank you.
Thank you. Thank you so much for having me, and thanks to the Law Council of Australia, Macquarie Law School, and Western Sydney University for organising tonight's event. Before I start, I would also like to acknowledge that we're meeting on the land of the Gadigal people of the Eora Nation today. I pay my respects to their elders past and present, and to any Aboriginal and Torres Strait Islander people joining us here today. As Amy said, I head up the Human Rights Branch at the Commonwealth Attorney General's Department, and my branch is responsible for preparing Australia's UPR National Report, leading Australia's delegation to the UPR, to the UN on our UPR, and then coordinating Australia's response to UPR recommendations. So my brief was to give you a bit of an overview of what the process is like from being inside the government in terms of engaging with the UN and the recommendations that we receive through that process. So some of this might be a bit basic for some of the experts in the room, but tonight I will give an overview of the UPR process, our engagement in the peer review process, and then Australia's fourth cycle UPR. And I will try to not take up too much time because I think Darren could probably also give my presentation, noting his experience in the Human Rights Commission since 1998. And I think that his insights are going to be fascinating. But I'll start with the UPR process in general. So as Amy said, it's a UN Human Rights Council process through which the human rights records of member states is reviewed every 5 years. And that's in line with obligations under the UN Charter, the Universal Declaration of Human Rights, core human rights treaties, and applicable international humanitarian law. As part of each cycle, member states submit a national report and they appear before the UPR working group in Geneva to engage in an interactive dialogue with other member states and then non-member observer states and respond to the recommendations they receive. The review process is informed by the member states' national report, and that covers things like progress on implementing recommendations from previous UPR processes, any new voluntary commitments a member state makes, as well as any broader progress a country has made in relation to human rights. It's also informed by civil society parallel reports on a country's human rights record, and my co-panelists will talk you through more in detail about those. It's also informed by information from reports of treaty bodies, special procedure mandate holders, and then other official UN documents that are relevant. During the appearance in Geneva, the state under review has 70 minutes to present their national report, to talk about their achievements and their voluntary commitments, to respond to any thematic issues that have been raised by the member states of the working group, and then to offer concluding remarks. And throughout that process, the member states will make statements and recommendations. After the appearance, the working group issues non-binding recommendations made by the delegations during the appearance. And the member state under review is required to respond to those via an addendum. And that's a written response, which has a very strict word limit of 2,675 words. And that's typically due within 3 to 4 months. And member states then address the recommendations in the next reporting cycle, and they can also, if desired, they can opt for a voluntary mid-cycle review process. So I'll move on to Australia's approach to participating in the peer review process for other member states. So as part of that, we make recommendations to all of the states that are making UPR appearances each session, and those sessions occur 3 times a year. For Australia, that's led by DFAT, the Department of Foreign Affairs and Trade at Post in Geneva. And in line with Australia's human rights priorities, our recommendations there regularly will focus on things like abolition of the death penalty, LGBTQIA+ rights, gender equality, rights of Indigenous peoples, freedom of expression, assembly and religion or belief, and national human rights institutions. To inform that and those recommendations, DFAT draws on inputs from civil society organisations, whether they be local ones in particular countries where the member states under review, as well as global civil society organisations' reports. And they also get local feedback from their embassies and high commissions based on the feedback that those government officials are getting from engaging with that member state. And then beyond that, once we've given those recommendations, a key part of how Australia engages bilaterally with countries is seeking updates on the implementation of those recommendations when they have bilateral engagements. And so that's an important way that we use the UPR process as a prompt to make sure that human rights are part of our conversations with other governments, and supports that peer-driven accountability function of the UPR. Moving then to our 4th UPR cycle, Australia's national report was submitted to the UN on 14 November 2025. My branch developed that report in collaboration with a range of the relevant Commonwealth agencies that have policy responsibility for different issues, as well as state and territory agencies. So the blessing of federation is that we share a lot of the different responsibilities across the different jurisdictions in Australia. We also took into account feedback that we received through a public consultation process that we conducted in August 2025, where I think we got about 47 or 42 written responses to submissions. In line with the UN guidance around what we should cover, that report focused on implementation of recommendations that we'd accepted in our 3rd UPR cycle, and the voluntary commitments made there, as well as broader progress on human rights. And then that report was accompanied by an annex which provided further detail on the implementation status of all of the 2021 recommendations. So That annex was 164 pages, so it gives you a quite extensive assessment of the implementation status of the recommendations that Australia accepted in 2021 and gives relevant information for recommendations that Australia noted for further consideration. So some of the key legal and policy developments that were adopted since our third UPR cycle that were highlighted in that report include things like significant work towards ending gender-based violence, delivering reform to stamp out hate speech through increased legislative protections, continuing to support the rights of people with disability, including through a review of Australia's disability strategy, launching the National Action Plan for the Health and Wellbeing of LGBTQIA+ people, boosting some protections for migrants, refugees and asylum seekers, and providing some significant support for humanitarian refugees. The report does also recognise that a lot of further work needs to be done on our human rights in Australia, and particularly to better support our First Nations peoples. Engagement with civil society is a really important part of the UPR process, including at that stage of developing the report. And for the most recent UPR to facilitate that, the government provided a grant to the Human Rights Law Centre to prepare an independent report, which is what Arif will talk you through, and that represented the views of over 100 Australian human rights NGOs. And then, as I said, as is standard with our UN reporting processes, the department also undertook a public consultation process to seek feedback on the draft report. And we got 42 written submissions in that process, which helped inform our draft. Following our report, then Australia appeared before the UPR working group on 26 January this year. And we received 332 recommendations, which is a lot to squeeze into that word limit that I flagged earlier. So that was from the 120 UN member and observer states. There was a particular focus around the human rights of First Nations people, including reducing rates of incarceration, raising the age of criminal responsibility, introducing a Federal Human Rights Act, improving the rights of refugees and asylum seekers, including ending offshore processing, ending gender-based violence, and strengthening protections for people with disabilities, older persons, and LGBTQIA+ people. Australia made 5 voluntary commitments during our appearance, and they included on issues around disability discrimination, Aboriginal and Torres Strait Islander housing, domestic and sexual violence, dementia risk reduction, and Aboriginal and Torres Strait Islander children and young people. So in terms of the next steps, it's a big volume to work through, and we don't get a long time to do it. So my branch is consulting across all levels of government at the moment to draft the addendum. We received the working group report with an early draft in late February, and then it was published in April. And so we are working towards consideration by the Human Rights Council in late June at this stage. So it's a significant body of work to coordinate, pulling together a position on all of those across all the different levels of government. So what the addendum will outline is whether we accept, note, and will consider further, or note each recommendation. Accept means Australia is committed to achieving a recommendation. Notes and will consider further is that we're progressing aspects of a general theme of a recommendation, but we have not or don't expect to implement the recommendation to the extent that's necessary for full acceptance. And then notes is Australia has carefully considered the recommendation, but is not currently in a position to accept it. And that could be for reasons including that there's not currently a solidified position or action on the matter. There's no further action that's considered or consideration that's expected over this next UPR period, or where government considers that the recommendation's inconsistent with Australian legislation, policy or practice. So we're going through a process of significant back and forth with government agencies to settle the positions. And some of them, it's tricky where some of them put forward a position for the whole of Australia that not necessarily all jurisdictions might agree to. So it is quite a brokering piece on some of them. And then it's a process of clearance through multiple ministers, in particular the Attorney General and the Prime Minister. And then just in terms of next steps, our responding addendum will be adopted in a plenary session at the 62nd session of the Human Rights Council in Geneva. So we're looking at likely the 30th of June. At that plenary, Australia will be provided with 20 minutes to present our views on the UPR recommendations and our voluntary commitments. And then we would formally address the recommendations we received in 2026 in our 5th cycle UPR, which would be expected to be in 2030. So hopefully that's a useful overview. I'm very happy to chat further in the questions.
I think that's a really helpful overview. It gives a sense of the scale of the UPR as well, and the responsibility of government in addressing those recommendations, given that there's such a substantial number. Darren, I turn to you now. As you're working with the Australian Human Rights Commission, and it is the National Human Rights Institution of Australia, you've been through 3 cycles of the UPR, 4 now. Could you speak to some of the positive developments, areas of continuing concern, and new human rights challenges that you see emerging through this process?
Sure. And if I can also acknowledge we're here on Gadigal land and also having this event on Mabo Day, a very significant Torres Strait Islander leader who's greatly changed our country. What I might say first too is that the Australian government from day one of the UPR has been very active participant in the UPR. They took the title of the UPR, literally Universal Periodic Review, and basically said every time a country appears, Australia will make recommendations to that country. So what happens, a lot of countries don't do that. They pick their friends or they just do it for some countries, but Australia says, no, this is universal for everyone. And it's been a kind of a leading country in doing that, and a number of others have kind of followed over subsequent cycles as well. And it's also, it was the major reform when the Human Rights Council was created back some 20 odd years ago now, I guess. And it's been an important development. The other piece of context is it kind of sits in distinction to the treaty body processes as well, where the treaty bodies, you ratify a treaty and then there's an independent expert committee that's assessing your progress against the treaty. Here it's your peers, your country, it's a country review at heart. And when you're an NGO and an NHRI, it's really fun, but it's really hard because at the end of the day, the recommendations that are made to Australia are the recommendations that are spoken into the record of the Human Rights Council on the 26th of January in a 3-hour session. And somehow we have to make our recommendations and they have to be spoken on the floor of the Human Rights Council for them to be adopted by other countries effectively. And each country had 60 seconds to make their recommendations. And they always spend the first 20 seconds going, you know, in the spirit of diplomacy, we commend you, and in the spirit of open dialogue, and you're like, just get on with it. Recommendations. And there's also no logical reason why they can't just submit their recommendations in advance rather than having to speak it on the floor in 60 seconds with a clock ticking down and then the chair just cutting you off if you don't get through it all. It's kind of a bit weird in that way. But in any event, the Commission and the NGOs in particular work really closely together. It's been designed as a tripartite process for government to have dialogue with their NHRI where they have one and with the NGO community. And so you do get these 3 main reports with the NGOs and NHRI in one, the UN and the government in that. So we take a very active role domestically. We started the process December 24, where we convened a workshop for government and NGOs to reflect on the 3rd cycle and to sort of get people prepared as to what was going to happen. So we tend to have the institution knowledge and memory happen. And then it leads up to us making essentially an independent report that went in July of the last year, several months before the government's report. So you're making your report before you've seen what the government's saying in many ways. But and the word limits are brutal. For the NHRI, it's like 2,700 and something words or something. So if you read our report, you'll see every issue gets one sentence, 2 sentences, you know, and then we have a footnote that has pages of content, and then we develop about 30 or so fact sheets that expand the information out in a meaningful way. So it's quite a challenging process to be engaged in. But the task then is having to, and we also do an implementation matrix. So we evaluate how we think the government went on the previous recommendations. Did they implement them? Did they not? And we score the government based on that as well. Then the challenge becomes an advocacy challenge of us having to convince every government in the world to make the recommendations that we have in our report. So we worked really closely on this, really closely. We convened a set of in-person briefing in Canberra, which we invited every foreign embassy and mission to attend. Then about 60 on, I think, of that. And then we ran 4 online sessions on specific themes. They were co-run by the NGO Coalition and the Commission. And then there's an NGO in Geneva called UPR Info, who are there to support the UPR process. And they run what they call pre-sessional briefing week. So they run a week about 2-3 months in advance of the UPR, and they run a session on Australia. And you have 6 speakers, the NHRI, 5 NGOs, who then speak to their submissions at that forum. I think there were probably 30 or 40 countries at that. And then we stay in Geneva for the week, and we go and we meet with missions around Geneva for the week. So by the time you get to the UPR, we've individually met with about 80 to 90 countries and indicated to them what we think their priorities are. Lolo, who works with me, did a lot of this work, but what we do is we basically map out what recommendations every country's made in the past, what have they made to Australia, what are the themes they've made across the UPR cycle, and then we target our recommendations to countries where we think it's their interest. And that's a fascinating process. And we met with the French, who traditionally will make recommendations on the right to protest, and they were like, yes, we normally do that, but we're cracking down on climate protesters at the moment. I don't think our government's going to do that. You've got another issue. You know? So you get into this political space. You don't get into that in the treaty bodies, obviously. It's a diplomatic process at heart, which makes it a challenging process in some ways. But that's the process of what you've got to do with it to get your recommendations done. And throughout that, we're engaging with government, and we particularly encourage government to make voluntary commitments, as Beck talked about, which is at the beginning of the process, the government gets up and says, here's 5 things we're going to do to take human rights forward in Australia. And we sort of encourage that to happen. This UPR, I think, been through 4, I describe this one as kind of a bit in the middle in terms of the outcomes of the performance. So the way I describe it is I think there's kind of 3 ways the UPR can go broadly. One is rights ritualism, and it's an entirely performative process. And a government says, well, we've got to do this, everyone's got to do it, let's just kind of make it the best we can. And they're not really that engaged, and they just do what they do and they get through it. That wasn't what this was. The second, I'd describe it like a health check. So, and the government, cleans its teeth before it goes to the dentist, sort of thing. And kind of goes in there and kind of broadly wants to see how they're tracking generally on human rights, but it's just like a health check. They're going to the doctor to check that things are kind of broadly okay. That's how I think this UPR was. The third version of it is it's an audit. It's right. This is an opportunity. Let's think about how we're going to take human rights forward in the country, and let's come up with some ideas and things we're going to do. We're not doing them at the moment. We need to do them, and we're going to announce these big priorities, and we're going to move forward. That's what we encourage the government to do. That's what the NGOs encourage the government to do. It's not what the government did this time. As Beck said, on disability, they announced that they're going to reform the Disability Discrimination Act 9 months, 12 months after the process of doing that had started. So it was already happening. So that type of thing. Important that it happens. So it's not a bad thing, but it's not kind of it's not using it as a reflective moment and then doing extra things as a result. So we think it kind of sits somewhere in the middle of that. At the end of the day, there was quite a high take-up of the recommendations the Commission had made and that the NGOs had made. Some of it's just copied and pasted straight from what we'd recommended to them. Others had seemed kind of slightly garbled language. There's a problem with the UPR that countries are being very diplomatic, so they use really soft language. Forever the advocacy in UPR is use smart criteria for your recommendations, make them really clear who's got to do what, when they've got to do them. But you'll see half the recommendations is that you should consider doing this thing. And governments are able to say, well, we considered it, so we met the obligation, rather than saying, do this thing. So the language is too soft, and it becomes a real problem if you literally take the language literally as it's written. It's a little bit too woolly and it's a little bit difficult to utilise, which is one of the challenges there. And that kind of leads you into what we think needs to happen with the UPR and for Australia and how we respond to it. And for that, what we sort of think there needs to be from the government, and it was there in the first cycle, but not since, is having like rights tracking tools where the government publicly says, this is our response to the recommendations. Now, they make it public through the UN, and they'll put it on the AG's website. And then who's responsible? When are they going to do it? What's the benchmark? That type of thing. And there's some public reporting around that. So a rights tracker is how this is commonly described. A lot of countries have them, Australia doesn't. So that's what we're encouraging the government to do. We're also really conscious that, there's 330 recommendations. A lot of them are the same recommendation, but it's a lot. And one of the trends in the UPR is to sort of encourage governments to say, what are our top 5 priorities, or what are our 10 key actions? So when the government goes into the adoption, they respond to the recommendations and they say, here are the 5 actions we're going to do between now and 2030. And we're going to do a midterm report in 2 years. And we're going to tell you how we're tracking on those issues. So not giving a generic response to 300 recommendations, but having a really targeted response to a smaller number of them. And that's what we're encouraging the government to do. And we'll see what happens. But this isn't up to Beck. This is entirely political will at the end of the day, and that is the challenge with it. So we hope for the best on this, but at the moment, as I said, it's been more of a health check, and the government's going, oh, we've done pretty well. We're a pretty good country, so we don't need to worry too much, rather than going, oh, we really should do something about the fact that we don't have a very extensive human rights architecture at the national level. We have a problem with racism, we really ought to do. Missions recommended an anti-racism. Let's do an anti-racism framework for Australia, that type of thing. So, so they're the types of issues that come up here. In terms of how well are we going, what we did after the UPR is we're quite conscious that it's quite an inaccessible process for the public and the community, and these recommendations are not easy to read. So we started a new process, and some of you may have seen it. The president of the commission, Hugh de Kretser, he addressed the National Press Club in mid-April, and he did what we called the Australian Human Rights Assessment 2026. And so we released this short document, which is we've called the report card, which is basically all the information from the UPR, but compressed down into a much easier way for people to access the information. So we've described it across 6 areas: democratic freedoms, economic justice, racism and migration, First Peoples justice, safety, equality and fairness. And against each of those, what we've done is we've put a list of what are the major achievements by the government, what are the urgent human rights issues, and what are the other priority issues for dealing with in this period. And that sets out fully our view on where human rights issues in Australia are at. And at the door, you've got the little card with the QR code that links you to that report card. And there's a set of 20 fact sheets, which might be very similar to the ones we did for the slightly different headings, which then takes you into the detail of those key issues as well. But what I'd say for us, the major focus in this, there's obviously, you can talk about First Nations issues, violence, disability, there's a whole lot of issues, immigration, there's a whole lot of specific thematic issues. But for us, where we're at as a commission is that we think there's a broader structural problem in Australia. So we ran a project called Free and Equal over the last 3.5 years. And the question we asked in that process was, what do we need to do to better protect human rights in Australia? And what should our national human rights look like? And so again, at the door, there's this little booklet, which is called 7 Ways to Improve Human Rights in Australia. And this sets out our model for a national human rights framework that would comprehensively protect human rights in Australia. And the core of this is a National Human Rights Act. as well as a modernisation of our discrimination laws, which are really out of date, developed at any time, the 70s, the 80s, the 90s, the 2000s, all completely different, conflicting provisions, extremely difficult to explain to people what their obligations are or what their protections are as they exist at the moment, as well as a national human rights education plan and a range of other measures. The other measures, I won't talk to them for time, but they're really about the accountability processes for human rights. So where does Parliament get involved on human rights? How does it scrutinise this? What's the sort of the way that the government sort of tells the Australian community what its commitments to human rights are? So we propose a national statement on human rights to the Parliament, where the government sets its human rights agenda every year, like they do for the national Closing the Gap process. They do a report card every year. You have a human rights report card, and you tell the story of Australia's commitment internationally and domestically. Rights. To give one example, it's a very technical example, but one of the things that comes up a lot in the UPR is around ratification of instruments, optional protocols to treaties and the like. And often what happens in the UPR is the government will say, oh, we'll accept that recommendation to consider whether we should ratify the individual communication process under the Convention on the Rights of the Child, which is a complaints process to the UN. And then nothing happens in that 4 years, but the government will say they've implemented the recommendation because they considered it. And we're like, well, how? We don't know. And often it will be, make this predecessor, but the Human Rights Branch and the AG's had an intern over summer and they looked at it. I was like, well, there's no public consultation. There's no engagement with the community. There's no national interest analysis by the Joint Standing Committee on Treaties. So a lot of this is about that elevation to Parliament and a line of sight that to them where they periodically review our reservations, say, should we be ratifying instruments? Should we have better consistency? Because some of it, when you look at it, it's quite concerning. There's a reservation in the ICCPR, for example, around hate speech, which I actually think should be removed now with recent other things that have happened in the past 12 months. But when you read the reservation, it says we're not quite in a position to meet the obligations under Articles 18 to 20, but we will be very soon, and we will remove this reservation as soon as possible. That's 1980. It's 46 years, and it hasn't happened. And there's been no consideration of how that reservation is removed. So we say that fundamentally that's a problem with the human rights framework that we have. And so we're pushing very hard for a national human rights framework that has these multiple elements that all sit together. And then underneath that, you would get benefits for every community and every sort of thematic group. Danny's here. I have to say, I mean, the Human Rights Act is the critical component for us in that, because you put that in place across all human rights obligations Australia has, and particularly you put in place a positive duty on government officials to fully consider human rights every time they're making a decision, every time there's legislation, every time there's new programs. And it just fundamentally changes the character of how you consider human rights in this country. So that to us is the critical missing step. We were pleased that we got a number of recommendations from countries about that in the UPR this time, probably about eight or nine. I think it wasn't a lot. There were others who talked about human rights framework, others who said comprehensively implement your human rights obligations and the like. But that's been our key focus and continues to be going forward, is to just get a better connection between that international system and the domestic system, so that you don't have this sort of thing that just comes up every 5 years. And when actually, if you look at the implementation matrix for the third cycle, and then you look at the recommendations for the fourth cycle, there's not a huge amount of difference between them. There's issues that are exactly the same status they were 4 or 5 years ago. There's some with some incremental change, some where it's been positive, but there are some issues where you go, nothing's happened in 5 years, or the 5 years before that, or the 5 years before that. And we need some better way to consider these issues, so that we don't reach what I said at the beginning of a situation where it's just performative and it's some sort of rights ritualism, and it's just a process that people go through.
Thank you so much. Very insightful to hear, especially given your historical engagement across the life of the UPR process at the UN Human Rights Council. So that's really crucial, but also speaking to the domestic implementation and the missing piece of the puzzle in relation to human rights protections. Aaron, I'd like to bring you in to talk about your experience because you have led the Australian UPR NGO Coalition, which is no mean feat in terms of bringing together all of those organisations. So it'd be really useful to hear your insight because civil society does play an important role. This is a tripartite process, so it would be great to hear your perspectives.
Great. Thanks, Amy, and thanks everybody for being here tonight listening about UPR. I've talked about this at length throughout the process of developing the report. It's good to see a lot of you here interested in this process. Also, I'd like to start by acknowledging that we're meeting on unceded land of the Gadigal people of the Eora Nation and acknowledge the First Nations people. Okay. In terms of the discussions that I want to touch on tonight, is around the NGO Coalition's perspective on the UPR process is a bit different to the government's and the Commission's perspective, but also the process of how we developed the report. Amy mentioned that I led it. It's more, there was a coalition of people, including community legal centres around Australia, NGOs, First Nations justice organisations. So there was a lot of organisations involved, and some of you are here in the room. And I see Graham Tom from ROCOA, Refugee Council of Australia, who've also contributed as a lead author in the report as well. So I'd like to acknowledge that contribution from civil society in the process. So as mentioned, it is a constructive dialogue between the government, the Commission, and civil society. So it differs from other UN mechanisms in that way. And we really took that at heart. So ensuring that the recommendations that we make in the limitations of the UPR process are actionable by the government, time-bound, and the SMART process that Darren talked about. So that was the constructive dialogue aspect was at the forefront of our mind. The issues around what the coalition focused on or how we came about was in late 2024, the NGO Coalition came about to prepare for the submission. And we have to acknowledge right now that given what's going on with the international human rights space, with the US pulling out of the UPR process, it was great to have the government's support in us being able to do the work. We received a grant from the government to be able to do this work. With that grant, we were able to bring together the Human Rights Law Centre, which is the organisation I work at, Kingsford Legal Centre, Community Legals Centres Australia, and the Indigenous Peoples Organisation Australia to help coordinate the NGO Coalition. That was in late 2024. From there, given the word universal, really, it is the key word in the UPR process. So it is an assessment of Australia's human rights record against all other international obligations. So it touches on a lot of issues. So there's, and also there are a lot of NGOs and civil society organizations who have priority issues. And bringing that together was the key issue. And we engaged in a process from the start where we brought together NGOs from different sectors to actually contribute to the issues that we want to cover in the report. So that was led by NGOs on the ground who work with people whose human rights are impacted on the ground. This included community legal centres, First Nations organisations, refugee rights organisations, disability, LGBTQI plus groups, organisations working on climate justice, faith and community groups. So these organisations helped to lead sections of the report. So there's 21 sections of the report. Each section was led by an organisation, an umbrella organisation in some aspects in the specific sector or the specific issue, and then others contributed as contributors to that section. So that was the logistics of it. It happened over maybe 3 or 4 months of consulting, firstly on the issues that should be covered, then on organizations interested in working on the specific issues that we all agreed that should be covered in the report, and then making sure that there's a cross-sectional lens applied to the report. The way that we did that was by ensuring that there was different groups and community organizations involved in each working group of the UPR Coalition. And most importantly, this time around, so previously, the NGO Coalition report was led by the Human Rights Law Centre, Kingsford, and Community Legal Centres in the last 3 cycles as well. But this time we decided the range of issues that impact First Nations justice in Australia. We brought on board Indigenous Peoples Organisations Australia to help lead that section of the report and also to provide that lens in other sections of it. So that was also, we were able to do that due to the funding as well that we received, and there was an open EOI process for organizations to submit to be part of the coordinating group. So that part of it was essentially logistics in terms of trying to get the group together, the issues that we want to work on, the issues we want to cover, and the makeup of the groups and the lead authors. So the report itself, it's a long report with a implementation matrix that is longer than the report itself, and footnotes that is longer than the report itself. It's available online on the Human Rights Law Centre's website. You can find those by putting in keywords like UPR, HRLC in any search engine. But as a brief overview, it makes around 140 recommendations across a full range of human rights issues concerning communities in Australia. As I mentioned, informed by First Nations justice organizations, refugee rights organizations, LGBTQI+ communities, children, women, democratic freedoms issues, right to climate justice, and health. So that was some of the issues that were covered in the report. So in the report, I think the commission talked about some of the consultations that they did, and the government also about the consultation and the back and forth with the departments that will have to develop their report. Ours was based on the lived experience of the community organizations that work on the ground with people impacted on the ground today. So what did the report say? Again, it is available online for you to have a good read of it, and I'm happy to chat about any of the sections and also to put you in touch with lead authors of the section. But in short, if we are really honest about Australia's human rights obligations and how it's doing, at best it's stalling from the perspective of the civil society organizations that coordinated the human rights, the NGO Coalition's report. And in a lot of places, it's sliding backwards. The clearest case in this respect is the First Nations rights. The referendum for the voice to Parliament was defeated, as we all know, 2 years ago. And since then, very little has been offered in place to ensure that First Nations people have a say in discussions, in decisions that impact their lives. And efforts to close the gap have also stalled. Another key concern for the NGO Coalition was youth justice. As we all know, Australia still jails children as young as 10, despite our international obligations, and despite this being a key issue in previous cycles of the NGO Coalition report, but also as part of the UPR cycles previously. Our treatment of people seeking asylum, including offshore processing, prolonged detention, it continues to be contrary to our international obligations. And in recent time, we've also seen hardening anti-migrant sentiment. So that was a key feature of the report as well. And the report also noted racism, hate speech, vilification, discrimination as a significant issue facing many communities across Australia, including First Nations, racial and religious minorities, and LGBTQI plus Australians. And as Darren mentioned, we are still the only Western liberal democracy to not have a federal Human Rights Act, which was also a key priority of the NGO Coalition. So after we developed the report, submitted it on the 17th of June 2025, we collaborated with the Commission really closely, and obviously Lola's here tonight, so it's remiss of me not to mention that it was great to work with Lola in arranging a lot of the briefings that we undertook in Canberra, with missions in Canberra, but also in Geneva when the NGO Coalition and the Australian Human Rights Commission went there for the UPR info pre-session. And in terms of our lobbying and advocacy post the submission, what we did was, apart from the briefings that we did with the Commission, we produced our own fact sheets with the help of pro bono support that we sent out to, I think, over 100 countries with our priorities for the recommendations that they should make to Australia. So those priorities, the key one that we sent to all those countries that we contacted was a Federal Human Rights Act. We also engaged in bilateral conversations with states around a report and recommendations that they could make to Australia, and in Geneva with meetings there. So what has come out of the review so far? So the review happened on the 26th of January. 122 countries made over 330 recommendations. The key things that for us, the key takeaways are that more than 40 countries, including Germany, Norway, France, told Australia to raise the age of criminal responsibility at least to 14. And that's been repeated over previous cycles as well. And that's a key issue for the NGO Coalition as well. At least 9 countries, including the United Kingdom, South Africa, called on Australia to legislate a Human Rights Act. There were also repeated calls by others for the implementation of the UN Declaration on the Rights of Indigenous People into domestic law, and for Australia to confront discrimination, racism, and to act on gender-based violence. More than 70 countries made recommendations around refugees and people seeking asylum, and our treatment of refugees and people seeking asylum. They explicitly called out our offshore processing policy. There were recommendations. These recommendations reflected the NGO Coalition's report, but also the Commission's recommendations in their report as well. So where to next for the civil society coalition from here? One thing that we have learned from speaking with colleagues who are involved in the previous UPR cycles is that the recommendations don't necessarily translate to government action on its own. So it requires civil society organization, yourselves in the room, to take this on, to look at the recommendations. If they're relevant to your area of work, use that in your discussions with government, in your submissions, in your advocacy. I understand that the government, as Rebecca mentioned, right now is deciding which of the 330 recommendations it accepts and which it merely notes, which is diplomatic word for setting aside. So it is on us to ensure that from here onwards, that we hold the government accountable on the recommendations made by states to Australia. I'm conscious of time, I'll finish up soon. So one of the key areas of concern that was highlighted throughout the UPR process in terms of our engagement with civil society was a lack of a national framework, a national human rights framework. And that was a key recommendation that we saw through the UPR process as well. My colleague Danny, who leads the Human Rights Act campaign at the Human Rights Law Centre, is here. One thing that all of us in the room can do is support that campaign. There are 178 organizations that already support that campaign. Right now there's been a lot of work done, as Darren said, through the Free and Equal, but also through the Parliamentary Joint Committee on Human Rights. In 2024, it recommended that Australia should legislate a Human Rights Act. The government hasn't answered yet, provided an answer to the PJCHR. So that's something that we're pushing on, and everybody else in civil society can push for. There's community support. So it is one area that would make a huge difference across the 21 areas and 140 recommendations that the NGO Coalition makes in its reports.
Thank you, Arif. And that's really helpful to think about ways in which we can try to promote stronger human rights protections within the Australian context. Nick, I'd like to pass over to you for some brief concluding comments. I'm conscious I'd like to allow some time for Q&A, but it would be brilliant to hear your perspective.
Thank you, Amy. I also acknowledge that we are on unceded land of the Gadigal people of the Eora Nation, and I pay my respects to their elders past and present, including First Nations persons with us this evening. Amy, in her introduction, neglected to mention that for 16 years I was the Director of Public Prosecutions for New South Wales. She thought that was a bit sensitive in a human rights session, I don't know. But in my defence, I will say this, that while I was DPP in my early years, I was founding co-chair of the Human Rights Institute of the International Bar Association, which now plays a very prominent part in human rights internationally, particularly amongst the legal profession and legal processes. So I'll hope that that balances the scale a little bit in my background. And in that capacity, I did actually address the Human Rights Council in its former iteration once in Geneva on behalf of the IDA, which was an interesting experience. I'm going to mention two things, and I'll do it briefly. One is to tell you about the Law Council's approach to this process and its contribution that it made this time. And then the other is to, as I've been asked to do, to make some closing comments about what we've heard this evening, without repeating, I hope, what we've already listened to with great interest. And I commend the speakers for the presentations that have been made. I am the chair of the National Human Rights Committee of the Law Council of Australia, and we have members from the profession in every state except Tasmania, but not also a member from either of the territories. And they are experts in human rights law and practice, supported by their respective law societies and bar associations. So I'm very proud to chair a very effective committee which supports the Law Council in its approaches to human rights issues. In the submission that we made to the UPR process, Law Council emphasised a number of particular areas. I'll just give you the headings. Child justice, which has already been mentioned. First Nations over-incarceration, which is a national scandal. First Nations people generally and the way in which they are being treated by society. People with disabilities. Housing issues. We see the figures of homeless people now blowing out in all our cities and towns. Freedom of expression. And human rights and the environment. Those were the areas that the Law Council's submission focused on. And our work in the Human Rights Committee is certainly very much concerned with the need for a Federal Human Rights Act, with child justice and with First Nations justice issues. You would know, I'm sure, that last week on the 26th of May, there was a private member's bill introduced by Andrew Wilkie, a human rights bill. it'll be interesting to see what, if any, impact that has on the recommendation that government already has before it for a National Human Rights Act. In the meantime, in New South Wales, there is a bill that has been presented, which is now before a parliamentary committee for consideration. It was introduced by the Greens in New South Wales, and the submissions on the for the parliamentary committee are due sometime early in July. So we'll see where that goes at the state level. Maybe bringing us in line with Victoria, the ACT, and Queensland. The need for the Federal Human Rights Act is becoming stronger by the day, and it's just so frustrating, as I'm sure we all feel. It hasn't happened. And child justice policies, it's very uneven across Australia. We see Queensland backsliding. Why am I not surprised? Sorry for any Queenslanders who may be present. It's sort of 2 steps forward and 1 step back in a lot of these issues, particularly in places like Queensland and the Northern Territory, and to slightly lesser extent Western Australia these days. But that doesn't mean that we shouldn't be trying to force the 2 steps forward every opportunity that we get. And the First Nations issues, I won't go through all of those. We are all very well familiar with challenges that are before us to properly recognise the position of First Nations people in our society. And it's a scandal that we've taken over 200 years to do it. In the early times, treatment was absolutely atrocious, as we all know. And to the extent that we've improved, we've only made really quite small improvements. A few comments about this evening. I again thank the presenters for the insights that you've shared with us this evening. It's very interesting to see the perspectives of the different organisations and sectors in the community to this process. I think from a couple of points from what Rebecca has told us this evening, it was heartening to hear that the process is used by the Australian government as a means to further bilateral engagement. And we see, from time to time, issues arise, for example, things like the death penalty in Singapore, issues of that kind, where some bilateral engagement and influence may ultimately have some beneficial effect. So it's encouraging to hear that is part of the program. She also acknowledged that there is more to be done, but that engagement with the NGOs in the field is an important part of the work of the government going forward. Unfortunately, of course, she's speaking for the federal government, and we have all the curses of federation visited upon us in this area as in other areas as well. Darren gave us a very good insight into the processes that are involved. And I think that you go down, give us a much better feel for what is happening and where some influence might be able to be exerted to improve the outcome. But I think the main point that I picked up from you was that we do need this human rights framework for the country to be advanced, be developed, be made more concrete, and for there to be accountability against framework. Right? And I know the Evidence Commission done a huge amount of work over a number of years in this very area. That booklet is something that you should get hold of if you haven't already. And there is, of course, the need to encourage action from NGOs as well as government. And Arif gave us some wonderful insights into the NGO Coalition's approach and what it's able to achieve. And I'm very thankful for what you had to tell us because it's most informative. It's a slow process. As he said, there is some backsliding time to time over a long period, seemingly necessarily involved. But again, the NGOs are in a position to push change. We should be unrelenting pressure that we bring to bear on the policymakers, the actors who are in a position to make a difference to human rights in Australia. We need to hold the government accountable in that area. So I think that's probably enough from me. Rest assured that the Law Council of Australia will be doing as much as it possibly can to advance the programs that should be pursued. And we do, I'm very happy to say, have very good relations and connections with the federal government. And we do engage constantly on all kinds of issues. So we hope that that will continue. Thank you.
Thank you. Thank you so much. I'm conscious of the time, but I would like to allow a couple of questions and then we can continue our conversations outside over our reception. So would anyone in the room like to ask a question? You can see a couple of hands up, Bill and then Wolfgang.
Yeah, my name is Bill Swanee. I teach human rights law at the Australian Catholic University. I do have a question for you, Rebecca. When I teach my students about human rights law, I often direct them to the website for the Remedy Australia organisation. And as you know, Remedy records the communications that are made against Australia and Australia's compliance with that. And on the Remedy Australia website, they show that Australia has complied with 9% of the communications that's been made against that. And I think it's a really damning statistic. And I want to go back to the third periodic review. And I think there were 344 recommendations that came to Australia out of that process. And from my memory, I think Australia accepted around 160 of those. And I wonder if you could sort of comment on, because that seems, statistically, it seems like just over half Australia accepted. And I suppose the third question is, you made a comment that I think you said Australia didn't accept some recommendations because they didn't align with Australian law. And I'm not sure whether I misheard you, but isn't that sort of a subversion about the principle that the international treaties are the standard and then Australian law and policy needs to comply with the international standards?
Thank you. That's a large question. I think in terms of where just that last point where I was saying that we might say, well, that doesn't align with our legislation or policy, that might be where noting that it's a peer review process rather than necessarily saying independently whether or not you're complying with the treaty. So it might be that we're not agreeing with an interpretation of how you would best support compliance with your human rights. So I think that's where I would say we would have landed on that position. In terms of the broader question around the percentage, I think absolutely we've got room for a lot of improvement. I'm not familiar with the Remedy percentage that you raised, but that's something that I'm interested to look into further. I think I hope that we can look at being able to accept more of the recommendations in future, but obviously that is, as I outlined earlier, the number that we can accept is a matter for government and for governments across the various levels of the jurisdictions that we have in Australia. So
I'll add to that briefly. On the remedy issue, it's been a really poor practice for a number of years if individual communications are made and then the government doesn't respond or doesn't accept them. But it's started to shift quite a lot as well in the last couple of years. So there was a significant one around Indigenous death in custody. I think that involved liability of one of the state governments, that the federal government accepted the findings and then entered into a process around compensation, I think, for that one. And the recent one around the Billy case in the Torres Strait as well, which is hopefully a reasonably good response. So we're starting to see that shift, which is positive. That's happened in the last 2 or 3 years, which is really significant. The issue the Commission still has, though, is that we haven't ratified all of the individual communication processes, as you know. So we don't, if you want to bring a complaint to the Convention on the Rights of the Child and the Committee on Economic, Social, Culture Rights, you can't, because those two protocols have not been ratified by the government. The government's view on that often is to say, well, you can still complain under the ICCPR, and that covers the same issues as the CRC. But I actually think it sends a message that children's rights are not as important as everyone else's rights. And that is one of the priorities that we say for ratification that ought to be fully considered by Parliament, and that should happen. One of the major ratification processes that's missing.
Wolfgang.
Thank you, Amy. My name is Wolfgang Barbeck, and I have edited a book where we compare the constitutional commitments of all countries in the world in terms of human rights. I have heard, firstly, I'd like to commend you all for the important work that you do. I've heard many very good things today. Arif, you said we are stalling. I think, yes, stalling, but at a very low level. Yeah? And if you read this paper, which I understand Nicholas Cowdery has also co-authored, it puts shame on us. We can do so much better. You know, we are in a situation you mentioned where the Queensland has abandoned its Human Rights Act twice because it has watch houses for children cannot maintain. You know, we had a UN Commission on Torture abandon its visits because it couldn't visit certain prisons, juvenile prisons, and so on and so on. And I'd like to point out what Darren said about, firstly, the human rights culture that we need to create, where, you know, everybody's involved, judges, government, but also legislators, to keep the human rights standards in mind. And that's why we definitely need this the National Human Rights Act, or better, constitutional provisions. But importantly, also, you mentioned education, yeah, because I think to create this human rights culture, we need to have education. Amy, you told me you were teaching 500 students. I think this is so encouraging. That is fantastic. And you're teaching students as well. So I would really like to, you know, probably later hear from you all, how can we get together and how can we improve, you know, a joint approach in creating this human rights culture across Australia much better. Thank you.
One final comment or question, and then we will close.
Chris Michelson from Western Sydney University. Thank you to all for a very interesting insight. So I have a very quick question, which is somewhat, I guess, the elephant in the room, at least as far as the Human Rights Council is concerned. And that is obviously that the Human Rights Council in itself as an institution is on a massive strain. Russia was expelled in 2022. The United States, for the second time under the second Trump administration, withdrew from the Human Rights Council. The financial situation is catastrophic. All the human rights special procedures are under stress. They have no money there. So the situation is pretty catastrophic, I'd say. And it seems to me that the entire sort of fourth cycle of Australia's engagement with it is sort of business as usual, right? So in a sense, from listening to tonight, no one, I think, would gather that actually the entire system as such is under probably existential threat. So my question is whether and to what extent this kind of geopolitical general situation in the Human Rights Council and the massive operational practical challenges the institution itself faces has had any impact on deliberations within government, deliberations within civil society. Because at the end of the day, if this is continuing the way it is at the moment, there won't be any sort of fifth review cycle in the future. So I do wonder whether, for example, it is time, in light of what Wolfgang and others have said, that there's actually a policy imperative for the federal government to not continue in kind of business as usual in this sort of lukewarm implementation of recommendations and this kind of very tactical, technical engagement with stuff to actually set a sign, that there is a real commitment. I mean, I was heartened by the fact, obviously, that Australia is still engaging in the universal review process, taking a stand, taking a view on every single contribution. But is it not time to do something a little bit more dramatic in defending the institution and the process as such? Obviously, I am acutely aware, obviously, Rebecca, that it's not your call to make that decision, but I do wonder whether it does feature in AG's, whether it's on the horizon at least. Thank you.
Brief response.
One thing I think happened in this UPR, this is my own personal view, having seen a number of them, is that over the last 18 months, Australia has stepped up big time in Geneva and has been like you remember the Canadian Prime Minister's comments around how the world should respond to Trump and various other things. We've stepped up and filled the void that's been there. And I actually think that there were quite a lot of soft recommendations to Australia this time. And I think it was out of respect for Australia stepping up as a significant player in the UN system. I think that had a material effect of us getting less good recommendations this time around, unfortunately. But it is the reputation at the moment. It's a very good ambassador in Geneva, and there's a lot of really good work being done, particularly as cuts are being made across the UN system to sort of assist in the decision-making around that. There's some really difficult decisions because it's catastrophic, as you say. I mean, the buildings, they turn off the escalators because they don't have the money to run them and stuff. And one of the options they're doing is to just disperse everything from Geneva out to regions. And Australia's in there going, we've just set up mechanisms for small island states so they can actually participate in these processes that happen in Geneva. They can't participate if it's in Vienna and Bangkok and everywhere around the world. And so trying to maintain a semblance of a system that is participatory for small states as well has been really important development they've done. That's kind of in the background. But there's a few things happening with the High Commissioner. His term's up in a few months, likely to be reappointed, and hopefully he'll be here in Australia in the second half of this year, in discussions at the moment about him coming out and doing some work with the Commission. But he's pushing this thing. I was just trying to look up the exact name. It's called something like the Global Human Rights Initiative, which is really about building broader community and NGO and NHRI and other collaborations and putting a lot of the momentum around human rights back into the community level. So he's really trying to sort of shift the onus and the responsibility, and everyone's seeing this as an urgent moment to actually kind of build on that and have a lot more momentum towards human rights. So it's going to be really interesting to see how he goes with that. But the other thing that I have to say from where I sit as Human Rights Commission is national human rights institutions. There's now 120 plus NHRIs that are A status, which means they are, independent, genuinely independent from government around the world. And it's growing. As Nauru has just set up its National Human Rights Institution. And I'm looking forward to the Australian Commission working with them to build their capacity and where that might take us, Graham, on refugee issues. Yeah. So this is growing and growing as a momentum. And I was representing the Commission last week at a UN meeting in Fiji about climate change and human rights issues. And what they are pushing for across the Pacific is for two things. They're pushing for a regional human rights mechanism that should involve Australia as part of the region, and national human rights institutions in every Pacific country as the two mechanisms to draw the connection from the global to the domestic. So I think it's a really good opportunity for countries to have to take responsibility for their human rights obligations and to expand their domestic protections, and hence again our human rights framework. But also, if I could just mention finally too, The other thing that happened recently on human rights that's really critical is Australia appeared before the UN Committee on Economic, Social, Cultural Rights in February for a review, and the concluding observations came out at the end of February, which is a copy of them. This is one of the best set of observations of a treaty committee that you're ever going to see. It's absolutely fantastic, and this is a roadmap for human rights in Australia in a really technical way. There's no diplomatic niceties in this document like there is in the UPR, and it's fascinating. And you know, I think maintaining those committees and making sure they're still going to be operating is going to be critical. We've got 5 treaty body reviews coming up in the next 2 to 3 years. The CEDAW is happening in October next year, this year, not next year. And with that, the ICCPR periodic report is currently out. Bex has put it out this week for consultation among the community. That'll then, when that goes in, it'll be about 12 to 18 months for the ICCPR review. We're close to this CRC review and also the CAT review. So there's going to be like 3 or 4 more treaty bodies in the next 18, probably 2 years, I think, which are going to be critical. But as to the system and how it's falling apart, the CRPD, the Disability Convention, it's confirmed at the moment that Australia's next appearance before that is in 2039. It's like 20 years between appearances. That's ridiculous. That's not a periodic review. That's a generational review at the end of the day. So there are serious problems there, but there's a lot of momentum and there's a lot of really good stuff we can work from. I really encourage people to look at ICESCA because this is seriously good as well. But I think we can still have hope, but we have to kind of take responsibility and know that that system is not there as much as it has been, and that we've got to build the domestic accountability.
I think in the interest of time, thank you so much to our panelists. I would ask you join me in thanking them for their amazing. I'd also like to do a few brief thank yous to thank my co-chair of the Human Rights Forum, Dean of Western Sydney Law School, Professor Catherine Renshaw, who couldn't unfortunately be here this evening, Simon Henderson and Dana Rutner, who together collaborated on this event, as well as the support of Macquarie Law School, Dean Professor Lee Sparry, and Associate Professor Shireen Morris, Western Sydney Law School, the International Law Section, Wolfgang, who is here today. Thank you all for your support and generous co-sponsorship in making this event possible. We have a catered reception outside, so there's still time to continue the conversations and learn more about some of the things that you can do to support and promote human rights protections and their advancement in Australia. Thank you.